After we can speak for by Mr. 8 years in the council of the Krishna. Both sides are represented. Huh? Yes.
May I appeal, Lordship?
Yes.
Lordship, I beg to mention for listing one WBC Lordship. Lordship,
Listing.
urgency that Lordship, petitioner is 74 years old lady Lordship, and police is searching Lordship.
Okay.
On tomorrow Lordship. Much obliged.
May I please your Lordship? I seek some accommodation in item number 4, Lordship. I'm been appointed as amicus in that case.
Okay. Here, what was the issue? Just remind us.
It's foreigner's case only, Lordship. She was declared foreigner. She has challenged that matter before this honorable court.
Okay. Okay.
Subsequently, I have filed one additional affidavit after being
Okay.
appointed.
Now I recollect what is happening. How much time?
A week's time, Lordship.
Same. This is a D Ghosh, counsel for the amicus curiae for the petitioner.
Deeply obliged, Lordship. May it please your Lordship? Lordship, prayer for listing on the
All prayer for listing, give it to the court master.
May I please your Lordship? Lordship, I beg to mention for item number 2, Lordship, my senior is in leave medical treatment. Under medical treatment for cataract of surgery, Lordship. So he is not able to. Medical documents are
name?
here. N. Khatun. On behalf of H. Bhuya.
On behalf of
H. Bhuya.
H. Mia.
Yes, Lordship.
Okay. Counsel for the petitioner.
Matter may be listed on 12th, Lordship.
We're giving it after 2 weeks. We are not fixing a date.
Obliged, Lordship.
Your Lordship, with respect to item number 16, if it may be taken before your Lordship rises.
Okay.
Much of.
Yes, great person.
Yes, I can do it. Basically, do it.
Yes. Yes.
My pleasure. Lord, I beg to mention item 12.
12.
This matter, my lord, supposed to be listed in the month of March, but it is not listed in the regular bench because of recusal by my lord Justice Chaudhary. So ultimately, on my instance, matter is listed today before your lord. So may I pray for my lord out of turn taking up the matter?
Okay, we'll try to take up because you are rising early today. There's a single bench matter.
If my friend is ready or
No, my lord, actually, our learned colleagues in the my lord, division bench, my lord, they are not coming, but they will appear, my lord. But I am completely unaware of this, my lord.
then my lord, may I pray because
So, maybe my lord fix on my lord next week, my lord.
because it will not go to the regular bench as per roster. It will, so therefore, a fixed date is required.
Okay.
Next Thursday, my lord.
That item 13 is tagged with item 12.
Take a look at it.
It will not go or you don't want it to go.
No, my lord justice has made recusal in this one. That is-
So therefore the question, it will not go or you don't want it.
already not made, not there is a order not by, so it will not.
Beyond that,
Next Thursday.
Thursday over in sir.
Oh,
Thursday. Well, Thursday, na?
So, date to be,
Our time.
Both sides are represented. On the joint prayer made by Joint Council for both sides. The arrest is adjourned today, list on 12. 2024.
I'm online.
But both sides, Mr. Sharma and Mr. The You'll have to assist us by giving this gist of the witnesses.
That I have already prepared.
Don't give an elaborate, but just what is that witness for? And what purpose he has come? Any point which is favoring you in that
Should I
evidence?
face today
No,
on that day?
on that day.
Already I have prepared.
Translated.
Translated. Apply.
Supplementary list item 15 spoken to.
Yes, we have listed the matter to express our anguish at your presentation. You have not prepared the brief, you have not read it, and you did not also go through the LCR. So this is the only case where we found that there is no assistance from the petitioner. So we have listed here to express our anguish. Now, please tell us. There are some issues which are favorable to you. So what is your, what will be your submission if something is found favorable in your, favorable to you? What will be your submission then?
My lord, the petitioner elder brother.
Don't tell us, you have heard us. We have expressed our anguish. Your presentation was hopeless. You did not go through the LCR, and when we saw it, we were surprised that you did not have the, you did not assist the court by looking at the LCR. You don't even know what is happening in the case. We have told you, we have called this matter today just to express our anguish. This is not the way we expect a lawyer to do a matter. If you're not prepared, don't take the matters. If you don't know how to look at the trial court records, don't do the matter.
So serious matters, the questions of citizenship. You can't be so casual.
So we are asking you only one question. If some point is favorable to you, what will be your submission? If in the trial court, third time I am asking you, if in the trial court record there is something which is in your favor, what will be your submission?
Which was not brought to the notice of the
Trial court.
You will never know. That's okay.
In the trial court, my lord. My.
You see, you are worse than hopeless. You don't have the courage even to ask what is in your favor. And you have started arguing. We told you that we are not inclined to hear you. Only one submission I am going to ask you. And this is for the fourth time. If in the trial court record something is in your favor, which perhaps the trial court also did not see, what will be your prayer? Ms. Verma, what do you think we should do?
Lordship, fairly speaking, though my friend has failed to assess this court, Lordship, if Lordship has found something in the records which favors the petitioner, Lordship will go by that.
But it calls for a remand then,
Yes, Lordship.
instead of this court taking up the matter
It has
on the
to-
original side.
Yes, Lordship.
We propose to send it back.
With that observation, what Lordship had.
Yes.
Lordship may,
You see, we'll tell you just to elicit the reply again. This is the fifth time we are telling you. You see what has happened in the trial court record, when you have seen it, we have found that after the witness was examined, cross-examined and discharged, then a document came on record, which is a police verification report where the father's name is ascertained. Now with that, the court never passed an order because you never, even in the trial court, it was hopelessly conducted. The lawyer perhaps has no idea how to conduct a foreigner's case. He did not tell the court that this report has come. The court, after hearing of the matter, the election commission, the election officer sends 3 certified copies of the voter list where your brother's PW2, DW2, his name is there. That was also never pointed out before the tribunal. So there is a link, and there is a certified copy of the voter list was never pointed out. You also met the hearing here. In the trial court, these things were there and nobody pointed out before the tribunal. So these documents were not taken into cognizance. The reliance was not placed on these documents, although it was a fit case for a additional written statement or written additional evidence. Now, you also did the hearing without consulting the trial court record. Either you don't know how to handle a trial court record, or you don't have the the zeal to excel in the professional work to assist the court. That amount of professionalism from you is not there. So we found you hopeless.
Do you want to file a review? You have a look into the records, satisfy yourself.
The prayer must come from you.
My lord, sometime may begin. In the meantime, I will go through the report.
Sometime. You are worse than the hopeless.
Otherwise,
Lordship may
If
give
you-
him an
if your
opportunity
lordship
to
found
go
No
further.
point hearing you. Please sit down. You are one of the hopeless lawyers we have come across. You hear us, we tell you the defect, you don't understand, you don't know how to make submissions like a good lawyer. Today, when there is a teacher's day, you are a sorry figure. Please sit down. You will pass orders. This Ms. Verma will just try to show you because this look at this. We are trying to say, Ms. Verma, that we deem it appropriate that the matter be remanded for a first decision. And
Lordship may kindly observe that those 2 documents which the tribunal has failed to appreciate. Lordship may,
yes.
yes,
only that.
Lordship, clearly put it up, otherwise maybe there also, they may miss it out again. In the order?
Has to be.
Yes, it has to be because these 2 documents has not been appreciated at all.
Yes. There is a judicial notice taken by the tribunal.
Yes.
There is no discussion on that. It goes in the favor of the petitioner.
The only one thing, Lordship, I remember from the last date, there are 10 brothers and sisters, but we have found, like in the records also, only one brother's name figures with the parents.
No, you see, but one brother's name, who is the DW2, is a.
He's there, yes, Lordship.
The
Lordship,
the DW2 name has come, which was
And
not
even
there
the
earlier.
police report has come.
Police report has come.
Police report has also come.
This police report has come with the instance of the tribunal.
And then
Tribunal
also,
has sent in to make an inquiry.
it has been missed out.
Missed
Something
out, not placed,
not placed.
not
Yes.
relied upon.
Otherwise, you would not have used so strong words.
Yes, Lordship.
When the trial court records are available, it is your duty to go through it. Understand what is this. If you are unable to assist the court, then what is the use of counsels appearing? We have to read files, we read files, we read the records. The purpose of counsels appearing is to effectively point out what you want to say and what are the defects or whatever is there is available in the record and how do you want to present your case. As simple as that. That's all.
You see, the only thing is that with after so much of work, when we get time to read the records, why can't you assist the court by reading the records?
That's cardinal principle. The records are here for what purpose? You are
see-
representing the petitioner.
You see, when we two, I can speak at least for my brother. When I and my brother were young juniors, we used to be trembling when appearing before the court. Not because we did not know it, but because we were apprehensive that maybe if we say something wrong, will it be misleading the court? Will it not be proper assistance to the court? And therefore, although we knew everything, but we had cold feet when standing in the courtroom.
Yes, Lordship. I have also experienced that only now I feel a little comfortable. Otherwise, I always had this fear, Lordship, of facing anything which would, even if it comes in instructions, like I've learned it, Lordship, no verbal instructions, only on documents you place.
You ought not to know trial court brief. Something which is unpardonable. Okay, we'll just pass on this. Last time we showed you the records.
Yes, I have seen it, Lordship.
Disposed of.
Reserved, Lordship.
Huh.
Orders reserved.
No, today, we're dictating the order.
Orders that
Sorry-
already been
sorry, my lord.
dictated. We thought it is proper to confront the counsel as to what is there in our minds. Because at the time when we closed the hearing, we had a different view. Upon going through the records properly, we found that this would be a complete injustice if we don't take into account this defect.
Yeah.
Therefore, we are required to confront the counsels, what we found in the records. When it should have been the counsels to point it out to us from the records.
That these were not placed.
This one fact was instrumental in turning the case in your favor, which you missed out. You did not miss out because you did not know. You missed out because you did not think it is necessary to go through the records.
Sorry, my lord, I have never gone through the record, that's why.
Don't do it. It's our pleasure. Go from bad to worse. Who cares? You go from bad to worse.
Make it a point to go through the records. Be confident that you have gone through the records. You know what is what. You may argue anything. The effect of you failing to go through the records would have resulted in miscarriage of justice. But if we had dismissed the petition, we are saying to that extent.
Mr. M. Shalim, counsel for the petitioner, is present. He also had Mrs. M. Mrs. A. Verma, and standing counsel for the FTC, Mr. M. Kuli, Leonard. H. Kuli, I'm sorry, H. Kuli, Leonard counsel, appearing on behalf of Mr. A. Ali, standing counsel for the ECI, Mr. R. Talukdar, government advocate, appearing for the respondent of 5. By while dictating the order on 38/2024, on a perusal of the trial court record, the court come across two documents of which, though the Learned Foreigners Tribunal took judicial notice, but was not considered while rendering the opinion. Full stop. Therefore, the matter has been listed again. Put the counsel for all sides to notice of the fact which was not of the documents which are not taken into account while the tribunal had rendered its opinion, which is impugned in this writ petition. Full stop. Next para. Accordingly, the matter is heard again. Full stop. The just stop here, then we'll dictate the orders in chambers. Huh? The remaining orders shall be dictated in the chambers. Okay.
All orders, item 16.
Yes.
May I please your lordship. My lord, the impugned order, page number 51, my lord.
Mr. Pang, you need this? Record?
What time?
Page number
51, my lord.
51. Yes.
The impugned order, my lord. Page number 52, my lord. May I read from here? Third paragraph.
Because the only question is that you'll have to satisfy. Last time we think you made some deliberations.
My lord, my lord,
This witness which appeared for you,
my lord,
his name appears to be different. And therefore you are connecting him
my lord.
by saying that that is his alias name. That the tribunal did not find it admissible.
Also, my lord, the tribunal did not appreciate the documents, the linkage documents, Jamabandi copy, my lord. That was not appreciated, my lord. Mainly because,
Which you are referring to page
uh,
52.
my lord,
You are referring to which page? 52.
my lord, the relevant portion would be, my lord, from page number 54, my lord.
54.
Relevant portion.
In exhibit, which is the document at page 53, which the tribunal did not.
My lord,
Appreciate
exhibit
according to
16,
you.
exhibit 16, my lord. Exhibit 16.
Where is that in the writ petition? Can I tell?
In the writ petition, my lord, this is page number, my lord, 79, the typed copy. The vernacular, my lord, page number 82.
Jamabandi, exhibit 9.
This was another, my lord. The one that we annexed here is exhibit 16, my lord. There were two, but we were
Okay.
given only one copy, my lord.
Exhibit 16.
Exhibit 16, my lord. Page number 82 is the vernacular.
Yes.
My lord, there is absolutely no whisper about this document, my lord. Absolutely no whisper about this document in the impugned order.
See this document,
My lord.
which is the doc number for this the Jamabandi, which is relevant to you? Doc number?
My lord, it is written, it's 391.
391.
391, yes, my lord.
Yes. Which is the remark?
My lord.
Which is the remark in your favor?
Remark is, my lord, this order dated 4/3/2014 Tarikot Namjari Gosarar
No, which page will you provide it?
82, my lord.
Page 82.
Yes, my lord. Right. Bottom, right bottom, my lord.
Bottom.
My right bottom, my lord. Right bottom.
Yes.
May I read, my lord?
Yes.
চক্ৰ বিষয়াৰ 4/2/2014 তাৰিখত নামজাৰি গোচৰ 1821/2013 14 মুঠ নম্বৰ হুকুম
F mutation, field mutation number.
field mutation.
This is a field mutation, I guess.
My lord, field mutation number হুকুম মৰ্মে
391.
291 দাগৰ মাটিৰ আমিৰ আলীৰ স্থলত উত্তৰাধিকাৰী পুত্রে নূর আলম পিতা মৃত আমির আলী, নূর আলম পিতা মৃত আমির আলী, সুফিয়া খাতুন পিতা মৃত আমির আলী, আসিয়া খাতুন পিতা মৃত আমির আলী আৰু জুবেদা খাতুন পিতা মৃত আমির আলীৰ নামত নামজাৰি কৰা হয়।
When did the person die?
My lord, that is a page number, my lord. Death certificate of the father, page number 69, my lord. The father died on 22/3/2007, my lord. Page number 69.
You have the original order of the mutation. That field mutation order, do you have an original copy of that? The certified copy, do you have that?
No, my lord. Whatever we have exhibit,
I'm asking the reason.
my lord,
You see, this shows that there was a field mutation.
my lord,
F is a field mutation.
my lord.
If that is correct, then during field mutation, the orders are passed by the settlement officer or assistant settlement officer. Circle officer does not normally join in at that point of time, because then it's a settlement operations, and in settlement operations, under the Assam Land and Revenue Regulation, he takes the jurisdiction of an assistant settlement officer or a settlement officer to pass an order. But here the order is Chakra Bikhaya. Chakra Bikhaya 3/3/2014 তারিখত Namjari order. In a field mutation, that's why we wanted to see the order as to how this person uses the seal and stamp of a circle officer to do it, because it runs contrary to Land revenue regulation.
I plead my ignorance. I am not aware of this, but we don't have this order. I am not aware of these processes.
Ah.
But your lordship is saying it will be correct, my lord.
Purpose of field mutation is then and there.
My lord.
They make an assessment, measure it, examine whoever persons are there, owners, neighbors, etc., and then pass an order.
My lord.
So therefore, the effect of passing an order is that he has settled his land in favor of these the
Petitioner.
persons whose names in which favor the orders have been passed.
We don't have that order with us.
Must be having. Where else?
It will be there in the position of the
Oh,
the circle officer probably.
Apart from this, is there any other document to show your that you are sons of?
My lord, there is a Gaubura certificate from Bilpar, but the Gaubura did not appear, my lord. It was not examined. And also one of the brothers, my lord.
Because we are doubting this document
My lord.
for a simple reason that your reference is of 98.
My lord.
This mutation order is after that. Therefore, trying to examine.
This had happened after the death of the father probably. Father died in 2007.
Along with the father whose name appears in the voter list.
My lord, along with the father, the siblings, my lord. The siblings even DW2, my lord.
Which voter list?
My lord, in the Jamabandi copy, serial number 25, Noor Jamal. He appeared as DW2. Jamabandi doesn't appear.
But again, this page for page 80 to 83, reading of this finds something more interesting.
My lord.
Serial number 25,
My lord.
Sri Noor Jamal,
My lord.
Pita Amir Ali.
My lord.
You come to the another entry of 37, Noor Jamal,
Voter is on
Pita
9.
Amir Ali. So one father will not have two sons with same name.
No, Noor Alam and Noor Jamal. They are two brothers, even mentioned in the WS also.
Noor Jamal.
Noor Jamal. One is Noor Jamal, one is Noor Alam.
No, both are Noor Jamal.
My lord, even the name of the petitioner has been mentioned double, my lord.
No, we don't know this, but you see, when I am reading this Assamese, I am reading Sri Noor Jamal,
My lord.
25 and 27, Noor Jamal.
My lord, even Jabeda Khatun is mentioned twice. Even Sufia
No, that
Khatun
is-
mentioned.
no, you see, you are trying to identify yourself as the son of the
My lord.
Amir Ali. So when the Jamawandi has two entries,
My lord.
Noor Jamal. Noor Alam. Second name Noor Alam.
Noor Jamal, 37 is Noor Jamal. 38.
32 to Noor Jamal. Just read the 82. Few words I can't read. 82 last part. Please read the names again.
নূর জামাল মাটির আমির আলীর স্থলত উত্তরাধিকারী পুত্রে নূর জামাল পিতা মৃত আমির আলী, নূর আলম পিতা মৃত আমির আলী, সুফিয়া খাতুন পিতা মৃত আমির আলী,
Just a moment. Noor Jamal.
আচ্ছা।
It is then Amir Ali.
আমির আলী
After Amir Ali. Oh no, sorry, late Amir Ali. Okay. No, Noor Alam.
নূর আলম মেলন,
After Noor Alam,
আহ, সুফিয়া খাতুন পিতা মৃত আমির আলী,
Sufia Khatun.
মাই লর্ড,
Yes, then
আসিয়া খাতুন পিতা মৃত আমির আলী,
yes,
আৰু জবেদা খাতুন পিতা মৃত আমির আলী নামত নামজারি করা হয়। রেপিটেশনের
Javeda.
মাই লর্ড, জবেদা খাতুন।
In your written statement, have you given these names?
Yes, my lord. My lord, page number 58, my lord. Page number 58, para 7.
Yes.
Para 7, my lord. Relevant portion. Relevant. Relevant portion. Naam.
Please come to the opinion where you said that this exhibit 16 was not considered.
My lord, page number 54, my lord. Page number 54. May I read, my lord?
Mr. Pang, if the documents exhibited are not considered, then we are giving him bail. The petitioner is entitled to a bail. Then perhaps by that time you can make an inquiry about that circle officer and all. But I don't think that would be more material. If it is not considered, we can next date remand the matter back. Instead of the court giving a declaration. Let the matter be
Otherwise,
remanded
your
back.
lordship may remand it, but I have seen my lord.
No, but we find it very
Yes.
difficult. You see what is happening. Now, once we remand it back, this means the
He may not
opinion is
accept.
set aside. Then they are not on bail. They are not required to be taken on bail. Once the opinion goes, then they are not within our reach.
They are not bound to appear, but.
They are not bound to appear. That is the difficulty.
Otherwise, my lord, yes, I have seen my lord, in the opinion, the learned tribunal has not considered numbers of my lord documents. But prima facie, my lord, the tribunal has only considered that only one aspect of the matter, my lord. What I want to indicate, my lord. That there are two sets of documents prior to 71, after 71. Prior to 71, it is Amir Sikh. It is my lord, grandfather name is Amir Sikh. And a father name is Amir Sikh. Prior to 71, it is Amir Sikh. There is no issue on that. After 71, there is no voter list at all of the father. Till 2007, when the father died, as per them, my lord.
But all this will have to.
Yes,
come out
these are not in the opinion, my lord,
in the opinion.
but the record says what I have seen the record, my lord.
No, but the difficulty is that that's why we are telling you. We called you to the chamber also for a reason. And I think there has been some development. I should speak to you again in the chambers. Ms. Verma, you and Mr. Payang, something to share with you. The chambers will tell you, may not be saying it here, but we are of the and then what we can do is that if that is the submission, then we can put a judicial seal on that so that whatever is happening can be kept on hold for some time. And in the meanwhile, say 15 days, 20 days or a month, everything can be kept on hold. And this training program should go on.
Lordship, this training should continue. What happens is one training in 3 years or one training in 2 years doesn't help that to half a day. It has to be a continuous process, like say once in a month, which is very important, Lordship.
No, that the state, perhaps when we take it on the judicial side, maybe perhaps the state can suggest a means and ways.
Justice Bhuya was here.
Can you identify that case number? Can you give that case number so that we can take it up again?
My lord, that in that case, that is a my lord, single bench matter. The monitoring bench is looking after that matter, my lord. And
Can you give us the case number?
yes, my lord, there it is already an
Mentioned.
observation that there will be a training program. So
No,
I'll put,
that's okay. But since we are taking away the revision bench, if you can have that, we'll see the records and we'll try to see how the things can be.
It has
When
to
we are
be-
passing
this
orders-
orientation is very, very important, Lordship.
I'll provide
No,
it.
you see, there are, Ms. Verma, the reason, and Mr. Pang, the reason is very simple. In fact, I was just sharing with my brother also. You see, once a person is a citizen of India, his rights are very valuable. Part 3 is very protective of them. But we, for some reasons or the other, one class of persons are left out. They don't come into the Part 3. Their rights don't crystallize under Part 3 of the Constitution of India. So whether that appreciation is correct or not is a thing which the state will have to take a call. And
Lordship.
therefore,
We'll discuss this issue, my lord.
Just give us this and-
I'll provide the case number.
Along
And-
with the APPs, even the members need orientation.
Yes, both.
Both
and just
Lordship.
be there in the chamber for 2 minutes and we'll
We will.
Yes.
share you with you. Aye. Or Mr. A.W. Aman, counsel for the petitioner. Mr. J. Pang, Leonard, standing counsel for the FT. Ms. P. Barba, Leonard, standing counsel for the ECI. As well as Mr. R.K. Talukdar, Leonard, government advocate appearing for respondent number 4. Mr. Pang will be for 2 and 5.
Yes.
Next para.
3 and 5.
By filing this interlocutory application, the applicant, who is the petitioner in the connected WPC 2058 of 2024, has prayed for releasing the applicant, who is detained in the transit camp at Matia on
2nd of July.
being declared as a foreigner of post 25/3/1971 stream. While opinion dated 28/8/2023, passed by the member, Foreigners Tribunal, 5th, Dorong, Mongolday, in FT within bracket, capital V, 5, Roman 5. Roman 5 capital, bracket close, case number 1992 of 2016, arising out of SP enquiry number 10514 of 98. Next part. The learned counsel for the applicant has submitted that in support of the defense of the applicant, comma, along with the affidavit, evidence on affidavit of the applicant and DW2, comma, as many as 19 documents were exhibited, which were marked as Exhibit 1, TO2, Exhibit 19. Full stop, however, comma, while rendering the impugned opinion, you see, while rendering the opinion impugned in the connected writ petition, comma, the learned tribunal has only discussed Exhibit 1, 2, 3, and 7. And the other relevant exhibits were not discussed, comma, which has prejudiced the applicant. Full stop. Next para. Per contract, comma, the learned standing counsel for the FT has submitted that has supported the impugned opinion, the opinion impugned in the connected writ petition, and has submitted that insofar as the name of the father of the petitioner is concerned, comma, his name was Amir Ali. The documents which are of 1971 and earlier.
Amir Sheikh.
That
Amir Sheikh.
Amir Sheikh. Amir Sheikh. Sheikh is SK. But the applicant is seeking her linkage to
Amir
Ali by projecting her to be the grandfather, to be the father. And thereafter, a defense is taken that Amir Ali and Amir Sheikh are same person, comma, which could not be established, and therefore he has justified that the learned tribunal has correctly held that the applicant, namely Zabeda Khatun, alias Zabeda, has not been able to establish a link with Amir Sheikh, comma, as a daughter. Next para, be that as it may, as we find that the learned Foreigners Tribunal has not discussed all the exhibited documents, comma, the court is inclined to grant bail to the petitioner, make the same language. Please. Speak. Here you just change the language that as the applicant is in the designated what you call transit camp at Matia and in Gwalpara, comma, what is the head called that in charge of the detention center? In charge of the that said transit camp, by whatever designation he or she is so. Appointed, would produce the applicant, namely Zabeda Khatun alias Zabeda, before the Superintendent of Police within bracket border, Dorong. Within 2 days from the date of receipt of a certified copy of this order. And on such production, then you make that sentence, huh? The 5,000 with all those conditions. Next paragraph. According to this, interrogatory application stands allowed. In the writ petition, you write. So. Next paragraph. The order passed today in the connected interlocutory application. No, don't say that. You just say that the as the trial court record is received, the same will require some appreciation, and therefore list the matter on listed it after 2 weeks on a date to be fixed by the office. In the meanwhile, the learned counsel for the petitioner shall apprise the court as to whether the applicant has been released on bail.
On the next date,
On the next date. Don't say in the meanwhile. On the next date, will applies. Okay. We are granting 2 days time. Yes, because he will be produced from Matia to Dorong.
otherwise your lordship can fix the date after the particular date. Yes. But fix a particular date, my lord.
Huh?
Fix a particular date. No, no. Appearance will run. Okay. Appearance will run. Within 2 days. Okay, but that will do. my lord.
After the certified copy.
You make it 23rd. This strong 23/9. 2024. Instead of 2 weeks, make it that day. Okay.
Item 3 for hearing.
Deeply grateful.
May I please, Your Lord? My lord, impugned opinion, lordship will find at page 62, very short impugned opinion. Page 62 is the my lord opinion. May I read the my lord opinion, my lord?
Just a moment. Did you file any additional written statement? Because in your written statement, you have not said anything.
Yes, my lord, no additional affidavit. My lord, page 63, lordship will find the reason. Their only issue, my lord, issue is, my lord, very narrow, my lord. Link certificate issued by the Bokebari Revenue Circle on record could not be proved. That is the, my lord, total, my lord, perverse findings, as we have seen from the, my lord, record.
Pardon me, please come again.
Page 63,
Yes, 63.
region portion, my lord, lordship will find. Middle portion, region.
Yes.
On perusal of evidence on record, the proceeding could not prove the link certificate issued by the Bokebari Revenue Circle Exhibit D on record. This is, my lord, something, my lord, perverse. We have seen the, my lord, record, my lord. That document, link document was proved.
Is it?
Yes, lordship will find Exhibit D. We have also, my lord, annex here, my lord. Page 59 is the, my lord, that certificate, link certificate. Page 59. Annex D. Sorry, my lord, Exhibit D.
Exhibit?
D, my lord.
Lordship, this document is only for the purpose of NRC, Lordship, at page 59. It cannot be used as a link certificate for any reason. Apart from that, if he has
Just
something,
a moment.
he should come.
And page 60, Lordship will find.
Just a moment.
Where is that certificate?
Certificate Lordship will find at page 59.
You have a good copy. There's something in the bottom line which is not photocopied.
It is a.
Do you have a better copy?
It is a disclaimer, Lordship.
No, but
You can find it in some other petition.
This document,
You must be having the original of these documents. अपना तक लाइव original copy. अपना तक आखिर वो लगे instruction. Actually, we have found one. In another matter, Lordship, which is item. Hasina Banu, 1 second. I have found it in another petition. It's a common one, Lordship. That's. Right to detail.
Raji?
Manawara Begum to litigation, Manawara Bega. Citation. No. If disclaimer will put into it as judgment as well into that. But this is only for the particular judgment as well. Yes, Lordship.
You please come to page 38.
Yes, Lord.
Now, this disclaimer says, it may be added that this certificate shall be accepted only as a supporting document for establishing link with parents of the aforesaid person for whom the from this certificate is issued. The document shall be valid or if shall be valid on accompanied by legacy data or any other admissible document issued for the person with whom linkage data is included. So if that is there, then this page 38 makes this admissible.
No, Lordship, it is not because NRC has not been notified.
No,
to
no,
date,
we don't know
Lordship.
that. But if we look at the plain text of the document, please see this again. It will, look, this
The
says,
disclaimer, Lordship.
yes, the disclaimer is a self-defeating document if NRC is produced. Because this is a legacy data, page 38.
This is only for the updated NRC. I may read it again, Lordship. It may be added that this document shall be accepted only as a supporting document for establishing links with the parents of the aforesaid person for whom the certificate is issued.
For whom
The certificate
the
is
certificate
issued.
issued.
Yes, this document shall be valid or accompanied by legacy data or any other admissible documents issued for the person with whom linkage
For the person with whom linkage is.
Linkage is that word for inclusion in updated NRC. It is only for the purpose of updated NRC, not for any other purpose.
No, you see,
Because this, if Lordship is referring to page 38, these were also never, these are documents which have been there in the records. It has been picked up from each district and digitalized. It was open to everyone. It was a public document. Anyone could access this and take a printout of it. So this one legacy data, when the family tree was examined, Lordship, this one legacy data had persons of about one family had persons, more than 200 people in them. But when they appeared at the Seva Kendras, one person did not know the other person, though they all, I mean to say, relied on this legacy data, Lordship. So that is how when too many people were using the same legacy data, when that scientifically that the data was uploaded, Lordship. I was there, I have seen it myself. In one village, if one Abdul Qudus had a legacy data, so in 4 districts, that same legacy data was used to show that he was there and he is related to them. So that is the reason there was a lot of hue and cry when the family tree was scientifically, they had to come to the Seva Kendras. People had to travel from one district in one end of Assam to the other district to prove that this legacy data belonged to them. And when people of one, say Mr. X, it was in Guwahati and people had to come from 4 districts, it was seen that they did not know each other. And it was at that point of time, it came to their notice that this data has been misused by most of the people just for the inclusion of NRC. And this document came after pursuance of the Supreme Court order. When married women had difficulty in proving their citizenship, they had to show their linkage with their parents. So this was only for the purpose of married women to show that they were linked to their father in that village for the purpose of updated NRC, not for any other purpose, Lordship.
Okay. Yes, Mr. Mandal.
Yes. Now, Lordship kindly see, my lord, page 60. 60, my lord.
Lordship, I can just, for Lordship's reference on this, the court master can take up this citation and replace it before Lordship later on. It is WPC 2634 of 2016. Manowara Beva, Elias Manora Beva.
I think this is reported matter.
Yes.
Yes, Lordship, it is.
It's gone to the Supreme Court.
Yes, and Supreme Court had certain,
Rupjan.
yes, and after that, Rupa Jan Begum was decided Lordship. Here Lordship would find the how this matter has been taken up and how this certificate came to be being and how this certificate is to be used for the purpose of NRC.
Okay, then Manwara Begum.
Manowara Begum. Manowara Beva.
We have that. I think we'll have.
It was decided on 28/2/2017.
Don't take print out, huh?
But page 60, Lordship will find the evidence of the Lord Lakmundal.
Just a minute. Manora Beba is the Guwahati decision.
Yes,
Yes.
Lordship.
Yes, 28/2/2017.
Yes, Lordship.
WPC 2634 of 2016.
Yes, Lordship.
Okay.
2364 of 2016. It was referred to a larger issue. This will give lot of clarity, Lordship, how the certificate is to be used.
You take down the citation, it will be 2017 2 GLR 632. Two 2017 2 GLR 632 and GLT it is 2017 2 GLT 143.
Lordship, 2017 2 GLR
632
632.
and GLT is 2017 2 GLT 143.
143. Yes, Lordship. নোটটা আছে নাকি একটু লেখা? In this, it was held that such certificates has no statutory sanctity, Lordship. This is the one line which was there in my notes, so I could find out. No, 18. Lordship, there's another judgment, may I refer Lordship? It's WPC 7088 of 2016.
Just a moment.
Name of the parties?
Lordship parties are Abdul Samad, alias Abdul Samad, alias Mohammed Samaduddin. And it was decided on 14/5/2018. Paragraph 15, Lordship, may I just read, it's a short paragraph.
Yes.
Exhibit 1 is a certificate dated 24/9/2015 issued by the Secretary of Mahakal Gaon Panchayat certifying that Abdul Samad was the son of Tota Mia. This certificate has the state emblem of India embossed at the top in the middle of the letterhead Government of Assam. First of all, a Gaon Panchayat is not a department of the Government of Assam and therefore cannot use the letterhead in the name of Government of Assam. That apart, under the state emblem of India, framed under the state emblem of India's so-and-so Panchayati Raj institutions such as Gaon Panchayats are specifically debarred from using the state emblem of India in any manner. Therefore, such unauthorized use of the state emblem of India has rendered Exhibit 1 inadmissible. Even if Government of Assam is written, it is not an admissible piece of evidence, Lordship. And in paragraph 16, it says in Rupajan Begum, Supreme Court has observed that certificate issued by Gaon Panchayat Secretary was meant to be a link document linking a married woman to her parents. Even then, Supreme Court had sounded a note of caution that such a certificate by itself is not a proof of citizenship. This has to be verified at two stages: authenticity of the certificate itself as well as the authenticity of the contents. Not to speak of such verification, this certificate does not even concern a married woman. Therefore, such a certificate would have no probative value besides being inadmissible in evidence. In addition, the author of the certificate did not prove the said certificate as well as the contents thereof by deposing before the tribunal on the basis of contemporaneous record. Lordship, we had certificates, maybe in some matter, Lordship may find, on the marriage certificates, it was written Government of Muslim. Government of Assam, below that Government of Muslim. We have come across those certificates also. And in this very thing, court had even instructed instructions to the Home and Political Department to carry out an audit search in the respective tribunals to find out whether there are any filed cases or where references have been closed as having abated. All such references, whether filed or closed as abated, should be revived and proceeded with as per provisions of the Foreigners Tribunal Order 64. The entire process should be completed. And when this happened, Lordship, we had more than 200 to 300 cases which came out.
Mr. Mandar, we'll take a just short break and come back. Well. Okay. What is this? So I want to this MRC. First time like this one.
One, where he has not stated from where he got the information to put it in the certificate. It's their Lordship.
And the next page, and the next page, 4 pages. No, only these 4 pages from the flag. Next page, page 2, after the flag, that is the notice given. And that 4th page, for the first time, we have seen that. I had never actually seen the original. This is a photocopy of the original register. Mr. Mandal, what is said in the morning,
Well,
you were hearing us.
well,
Same thing applies to you also.
yes, I am deeply obliged.
Obliged.
Yes,
No, you should be sorry.
because I have gone through the Muller record. That's so.
You have not gone through it. You have not gone through it. Mrs. Verma will
Right.
vouch for it.
Particularly Muller Exhibit D. That is
Ms.
the
Verma will vouch for it, that you have not gone through it.
Muller.
May I just read one paragraph from Upajan Begum Lordship? Paragraph 15 says, the certificate issued by the GP secretary merely acknowledges the shifting of residence of a married woman from one village to another. The said certificate by itself and by no means establishes any claim of citizenship of the holder of the certificate. This is made clear in the illustrative list of documents itself by specifying the same to be only a supporting document. The certificate in question only enables its holder to establish a link between the holder and Agupajan Begum Lordship. It's a Supreme Court of 2018, 1 SCC 579. 18, 1 SCC 579. Yes, Lordship. Paragraph 15, Lordship. It is a little bit long judgment. If I read from the beginning, how this certificate came into being will come out Lordship. Mona Deva was before a larger bench.
Type 7.
579.
Okay. Rupa sir. Paragraph.
Paragraph 15 and 16. Understand that Lordship, we can even start from paragraph 4 Lordship. How this matter was taken up as a larger issue by the Supreme Court Lordship. Paragraph 4 Lordship. Lordship, may I read it? Paragraph 4. The writ petitioner Manovara Deva, alias Manora Deva, in support of her claim to be an Indian citizen, had additionally laid before the High Court a certificate issued by the Gaon Panchayat Secretary of the kind noticed above. The High Court could have and in fact had decided the writ petition on the basis of the materials laid before the tribunal without adverting to the aforesaid certificate, and on that basis could have terminated the proceedings in question. However, the High Court took the view about the question of validity of the certificate issued by the GP Secretary is of considerable public importance and needed a resolution. Accordingly, the High Court, after dismissing the writ petition on merits, went on to answer the aforesaid question, terming the same to be a larger issue. Paragraph 5, as the opinion of the High Court holding the said certificate to be invalid has the potential of affecting a large number of persons who were not before the High Court, a series of special SLPs have been filed by such persons before this court challenging the aforesaid part of the order 1 of the High Court. Leave to file special leave petitions has been granted and grievances raised have been heard. The appeal arising out of the SLP filed by the aggrieved writ petitioner before the High Court has also been entertained and heard along with the above group of appeals. Paragraph 8, a reading of the order of the High Court would go to show that according to the High Court, the document in question was a means to facilitate a claim for inclusion in the NRC by reference to a document which is post 24/3/1971, cutoff date on the basis of which citizenship under section 6A of the Citizenship Act 1955 is required to be determined. The High Court took the view that all the other documents listed in the illustrative list of documents admissible are prior to the cutoff date, and therefore there cannot be any special reason for inclusion of the said document, that is contemporaneous GP certificate, secretary certificate in the said list, even as a supporting document. In this regard, the High Court took the view that this court in Sarbananda Sonowal 2 has laid that the state of Assam is facing external aggression and internal disturbance on account of huge influx of illegal migrants, and keeping in mind the seriousness of the problem, the use of the document in question to establish citizenship for inclusion in the updated NRC cannot commend for acceptance. The High Court also took the view that under the provisions of the Assam Panchayat Act 1994, issuance of such certificate is not contemplated and or authorized. Referring to the provisions of the Evidence Act 1872, the High Court was also of the opinion that as the said certificate is not issued by the GP Secretary on the basis of any official records, the same is not a public document, and in fact, the said certificate partakes the character of a private document issued by the GP certificate. The evidentiary value of the same, therefore, is open to serious doubt. It is on the aforesaid broad basis that the High Court thought it proper to invalidate the certificate in question. The invalidation of the certificate, which was an agreed document in the matter of processing of claims for inclusion in the updated NRC, undoubtedly has the effect of affecting a large number of claimants who may have filed the applications for inclusion in the NRC. It may therefore be necessary to very briefly notice the circumstances in which the illustrative list of documents, including the certificate of the GP Secretary appearing at serial number 13 of the said list, has come into existence. A set of modalities for preparation of the NRC was formulated by the state government through a cabinet subcommittee. The subcommittee, which was initially constituted on 3/8/2010, had been reconstituted from time to time. The modalities were discussed after several rounds of deliberations with various stakeholders, including so-and-so. The list of documents were part of the aforesaid modalities, which after being finalized by the state were sent to the Government of India. The approval of the union government of the said modalities was communicated by letter dated so-and-so of the Union Home Secretary addressed to the Chief Secretary of the Government of Assam. After the aforesaid approval of the Union Home Secretary, the State Coordinator NRC informed the RG of India of the decision of the Union Government and sought instructions of the said authority. RGI with regard to issuance of such certificates, this was communicated by letter dated so-and-so in response to so-and-so. Therefore, the State Coordinator by communication issued on the same date informed all the DCs of the states of the decision of the RGI and the approval of the format of the certificates that are to be issued by a GP Secretary in rural areas and executive magistrate in the urban areas for married women migrating to a new place on account of marriage. The required protocol to be followed in issuing such certificates was also communicated by the said letter of the coordinator dated so-and-so. From the above, it would appear that the list of illustrative documents, including the GP Secretary certificate, were agreed to by all stakeholders in the process of updation of the NRC, and the same also had the approval of the Union Government as well as the state government, pursuant to which instructions were issued to the district level officers in the matter of issuance of such certificate in tune with the required protocol. The exercise in question was undertaken by the High Court to consider an issue not strictly arising in the proceedings before it. Resolution of the issue was not indispensable for answering the writ petitions under consideration of the High Court. The issue had the potential of affecting the large number of citizens who were not before the High Court. No notice under the provisions of Order 1, Rule 8 of the CPC was also issued to enable the persons likely to be affected to contest the matter in a representative capacity. though the order 1 of the High Court insofar as the issue of the validity of the certificate is liable to be interdicted on the above basis alone, we are of the view that we should proceed further in the matter and record our views on the issue of the validity of the certificate in question to dispel all doubts in the matter and to avoid any further litigation on the issue. The certificate issued by the GP Secretary merely acknowledges the shifting of residence of a married woman from one village to another. The said certificate by itself and by no means establishes any claim of citizenship of the holder of the certificate. This is made clear in the illustrative list of documents itself by specifying the same to be only a supporting document. The certificate in question only enables its holder to establish a link between the holder and the person from whom legacy is claimed. It has been made clear in the several reports of the learned state coordinator that a claim accompanied by such a certificate without details of the legacy person is to be discarded, and in the event information as to the legacy person has to be furnished, the certificate in question is to be used for the limited purpose of providing a linkage after due inquiry and verification. The certificate issued by the GP Secretary by no means is proof of citizenship. Such proof will come only if the link between the claimant and the legacy person is established. The certificate has to be verified at 2 stages. The first is the authenticity of the certificate itself, and the second is the authenticity of the contents thereof. The latter process of verification is bound to be an exhaustive process in the course of which the source of information of the facts and all other details recorded in the certificate will be ascertained after giving an opportunity to the holder of the certificate. If the document and its contents are to be subjected to a thorough search and probe, we do not see why the said certificate should have been interdicted by the High Court, particularly in the context of the facts surrounding the enumeration and inclusion of the documents mentioned in the illustrative list of documents as noticed above. In fact, the said list of illustrative documents was also laid before this court in the course of its proceedings held from time to time, and this court was aware of the nature and the effect of each documents mentioned. So, Lordship, this has very clearly said that this certificate cannot by any means be a proof of citizenship. It has been clarified in this judgment by 2 judges of the Supreme Court, Lordship. And even the last paragraph also says we set aside the order of this so and so issued by the GP certificate is concerned and allow the present appeals to the above limited extent. Lordship, the last paragraph says that the certificate.
In the facts of this case, in the facts of the present proceeding,
Yes, Lordship.
the judgment supports the petitioner.
No, Lordship.
Why?
This was only for the updated NRC process, not for any other purpose, Lordship.
This judgment says this certificate is to prove the linkage of a
Link-
married woman.
Linkage of a married woman only for the inclusion of her name in the updated NRC, Lordship, not for any other purpose. This is very clear, Lordship.
Number one.
Yes,
Number
Lordship.
two, the certificate has to be verified at 2 stages. First is the authenticity of the certificate
Yes, Lordship. And the contents.
and the contents. Now, what
It-
about
it
the
is-
admissibility of the certificate? Admissibility of the certificate in evidence?
Lord, I'm understanding what Lordship is coming to. It was at that point why these 2 ways were put for the
No,
to
no.
verify the
We're
certificate.
asking this for a specific purpose. You see, Mr. Mandal has shown that this Lat Mandal came as in the witness box. And he also exhibited the document. That means the contents has also been
Proved, I
proved.
have seen it, but he has nowhere mentioned, he ought to have mentioned that it is only for the purpose of NRC. In other
No, but
evidences,
you are not-
lordship, we
no,
have
there is
seen
no
that
cross-examination.
in
this-
his cross. He has not stated, he said he has issued. I have seen that, lordship, but he has failed to mention for what purpose he has issued.
No, that was for the state to ask. State did not ask it.
No, lordship, even if the state has not asked, but these judgments are absolutely clear. If one person makes a wrong, it doesn't mean that we also follow the same wrong, lordship.
No. What we want to say, the ratio of the judgment is that such a certificate is not a proof for citizenship.
No,
We agree. But it can
For
be
the
used
purpose-
for the purpose of a linkage of a married woman.
only to show her linkage with her father.
Exactly.
That is it. But that does not again make it an admissible document to grant her citizenship, lordship.
No. That's where the second question was put.
Admissibility.
The certificate will be examined at two stages, verified at two stages. First is the authenticity. There is no dispute with regard to the authenticity that it's a false fabricated certificate. Second is the contents thereof.
Contents has to be supported by what materials were given for her name to be there. The Kabinnama ought to have been there, lordship. She has to produce that Kabinnama before when these certificates were issued, lordship, not one or two. Thousands and lakhs of these certificates were issued in every village where married women were there.
Where was the examination done?
So that is it. It failed at that point of time, lordship, because when the certificates were issued, it was a mad rush to just get the names included in NRC, lordship.
So therefore, according to you, it should have been examined. This should have been verified, the contents.
Yes, lordship, I have just read paragraph 16. I am coming to it again, lordship. It says the certificate issued by the GP secretary by no means is proof of citizenship.
Correct.
Such proof will come only if the link between the claimant and the legacy person, the legacy certificate which they were holding, lordship, is established. Yes, the certificate has to be verified at two stages. The first is the authenticity of the certificate itself, and the second is the authenticity of the contents thereof. The latter process, lordship may kindly come with me here, of verification is bound to be an exhaustive process in the course of which the source of information of the facts and all other details recorded in the certificate will be ascertained after giving an opportunity to the holder of the certificate. Lordship, this is very much there in most of the cases in the evidence, in the cross.
Please to verify.
Only yesterday I got a nowadays from that University of WhatsApp. I got a very interesting what you call
Forwarded message.
forwarded message. A man climbs up the what you call clinic to get a certificate of health, and he says that he has come to the doctor to get himself medically checked. So he said, "What is there?" So he asked him a few questions. Number one, this is my fees. So he says that no, here it is written is free. Okay, your eyes are good. Then he says that you have climbed up the 3 floors. Your
Heart
legs are good. Your heart is good. And so therefore in 2 minutes he says that your checkup is done. Go back. So you see, exhaustive process for a medical checkup is already we know. Some of it we know. We may not know the entire thing, but some of how health checkup is done we know. But if a doctor, in context of this case, we are asking if the doctor says that this is how he does a health checkup. Now, what will the patient do?
My humble submission, lordship, is I understand lordship says the contents are proved along with the legacy data. The contents here, lordship, that is when I asked whether what was the source of the name coming up, then that is what lordship has shown me from the records. Only the names which have come later on, not they never came up when that certificate was issued, they came up during the proceedings of the tribunal.
No, that only confirms because that document, that evidence was there, but it is confirmed only with the subsequent this document. The proceeding always claims
Yes,
that is the projected father.
What I have seen, my lord, the SP, whatever forwarded, those are confirmed of the, my lord, NRC. We
For the
have-
purpose of
No,
NRC.
no, those documents are NRC. That is not an issue, my lord. The NRC in the NRC, his father's name is there. Now,
Hmm.
what the next issue is the certificate.
Look at the contents.
Yes, what is the
You read
contents
the
of the certificate?
contents. You read the contents.
Yes,
Yeah, but-
certificate.
Yes, yes.
The certificate says, madam. This is to certify that. The certificate page 59. This is to certificate Indrajan Bibi, daughter of so and so. Whoever it may be, madam. Srimati Yamuni Bibi of so and so village under Bogiburi village is district Assam so and so. Aged about 57 years, was resident of the said village of his father's village area. Srimati so and so got married on 5/1/76. These are the facts given in the certificate.
No,
madam.
this,
Date
you
and-
see, no,
Yes.
you dissect it.
Yes,
Now you see,
so no,
according to this certificate,
yes.
the proceedee is, who is the father of the proceedee?
Proceedings father is late Jamesuddin, say,
Then,
Tomesuddin.
then,
Tomesuddin. And mother is,
according to you, that content has been proved or not proved?
well, that content is not proof. One Tomesuddin is there, that is proof. NRC, in the NRC, Tomesuddin is there. But NRC, my lord, from the document submitted by the SP, it is nowhere said this. Indrajan Bibi is, my lord, along with Tomesuddin. Had it been there, there was no issue at all. In those documents, Indrajan, this petitioner, Indrajan Bibi is not along with my lord Tomesuddin. How can the certificate, the person can give the certificate that Indrajan Bibi is the daughter of Tomesuddin on the basis of those documents? In those documents, Tomesuddin is there. We have absolutely no problem on that matter. Only thing is that on what basis he has given that this Indrajan is daughter of Tomesuddin. That fact is not there. Those documents are not there. Even, my lord, in the
You see, there's a big gap here. Unless, that's why we said that unless you have support from your, the government in the revenue, there are some things which doesn't make sense. You see, the government for all purposes takes a Lat Mandal report when it requires them to issue a legal aid certificate. Now, how do you accept that?
my lord, I don't know on what basis they are
It's not
accepting.
that. You see,
Yes.
you may not know one thing, but you have heard about legal aid certificate. So legal aid certificate under the revenue manual, it can be issued for debts and securities not exceeding 2,500. Correct.
Probably, my lord, they should
So,
make an inquiry
This
prior to
2000,
that.
no, this 2,500 is forgotten by everyone in the revenue department. And they give legal aid certificate or a legal aid certificate for properties which are worth much, much more higher than 2,500. So, but the government is accepting it. For every day, every purpose, legal aid certificate comes on record, be it a MSCT case, be it a application for death on account of accident or police killing. You have your own certificate where there is a requirement to have a legal aid certificate. Now, can a government speak in two language? You, for one purpose, you make a direction in your notifications saying that legal aid certificate must be brought. Somebody dies who is in government servant, for the purpose of pension, family pension, you have that certificate. For all purposes, you use it. When it comes to mutation, you must have a certificate. You see, it's the same Lat Mandal who is issuing a legal aid certificate and also issuing mutation orders. But he requires two documents by his own. Why in one go He can't do both things, but he will not do it. Obvious reasons are obvious. You also know. So therefore, the same document is being authored by two documents are authored by the same
Same
person.
person. How can it be, my lord?
No, why it should be, not how it can be, but why it should be. But for all purposes, you are accepting it. So why an exclusion in this case? That is for the government to establish.
My lord, that is a different issue, my lord. Whether that is accepted by the revenue department, that is not
No,
our.
you are
because
questioning
we are
on
not.
what basis they have done it.
Yes, my lord, whatever.
If you ask that question,
Yes.
then perhaps without me doing a DNA test, I will not be able to satisfy anyone that who is my father, who is my mother.
My lord,
That is something which is not
yes,
expected.
my submission will be, my lord, in that case, in that supposition, that proposition, my lord. What my understanding is, my lord, the Lat Mondal has to make his own assessment before issuing that certificate, whether he has visited that place, whether they are actually residing in that, those has to be there. I don't think there is any kind of record. My lord,
But that is how your deputy commissioner's office function.
yes, my lord.
You see, you take a brief, go tomorrow morning to the deputy commissioner's office, file a 144 case for XYZ, and you will find the executive magistrate writing an order. Heard so and so,
Sitting-
satisfied that there is a breach of peace. In the evening, you send your friend Mr. Talukdar, and he goes.
Oh, no,
And in
that
the
is-
evening, he will write, heard Mr. Talukdar, I am satisfied that there is no apprehension of breach of peace.
At
So
least-
from morning to evening, the satisfaction is recorded. Morning is satisfied with you. Evening is satisfied with Mr. Talukdar. End of the matter. Now, who questions the satisfaction of that officer?
Nobody questions. my
Nobody
lord.
questions that.
That is true, my lord. But citizenship issue in this case, my lord, because
No,
it
we are
is a
not dealing with the
question of-
issue of citizenship.
Yes,
We are issuing, we are examining an issue where somebody has been declared as a foreigner
yes,
by an opinion.
my
So
lord.
we are not declaring that he's a citizen or not. We are now seeing the order of the tribunal. That is, tribunal's finding is based on what? So now if there's the principle of evidence, the witness of this Lat Mondal is recorded.
Yes, witness,
No
your lordship may
cross-examine.
kindly see the witness also. I want
No
to show.
cross-examination.
No. That's what he has given, my lord, what he has stated, my lord, page 60. What he has stated, my lord.
Exhibit D is
is
the
the
linkage
link certificate
certificate.
issued from the office. Yes, that is, my lord, this present certificate. The certificate, page 59. Then what he has exhibited, in the certificate, it is certified that so and so is the
daughter is
daughter of so and so. Exhibit D is my signature. Exhibit D2 is the seal and signature of the officer. So, my lord, the authenticity of the documents, there is no issue. He issued this certificate. Exhibit D3 is the round seal of the officer. Only statement is the contents of the certificate is true. What can he give this statement without any basis of record, without any record?
No, who is questioning him that he does not have a record?
No.
Lat
Well,
Mondal is accepted.
It
Expected
is
to
their
do that.
evidence, my lord. They brought the evidence.
No.
It is their duty to prove
Negative
by
is not
bringing, my
required to
lord,
be
the
proved.
records.
Mr. Payang is unacceptable. Negative is not required to be proved.
We are not saying.
You see, you stand in evidence and you say that land belonging to land measuring so and so, I am the owner. Now, the requirement of law is that one has to give a correct description of the land, the land documents. Now, please tell us, if you are the original Patadar, you will not have a sale deed. You are the original settler
Settlement.
of the land.
Yes.
Therefore, at that point of time, when this, when the position is in your favor for 30 years, you don't have to also require to prove any other thing. So that is how we know the law of evidence operates.
No matter
The
as
requirement is, you see, if the requirement is that some, you see, does the tribunal has no duty at all? Supposing a document is not there, and the witness is also not cross-examined on the point, You say you have a trouble with your neighbor. You prove the document. There is no cross-examination that I am the owner of the land. He does not ask anything. He does not give a contrary evidence. He does not have any document to show that land is his. He does not give any evidence. And then the court, after some time, dismisses your case saying that, well, you have proved everything, but that Jamamandi copy was not there.
Oh, my lord, here only.
Or the
question
chitta is not there.
On what basis he issued the certificate? The certificate has to prove on the basis of some record. He has
No.
to.
Please see, don't always forget order, what do you call, Evidence Act 115 illustration E. All official and judicial acts are deemed to be correctly done. What happens to that? Therefore, you are questioning how the government is functioning. Is it open for you to question that?
As your lordship has already read
No,
out,
no.
but the honorable apex court has said in the present
No, you see,
context, my lord.
please tell us, are you questioning the government's, the authority of the officer to do it? That you are not doing. I'm not questioning anything. I'm just asking you. So if it is regularly performed, illustration E. All official and judicial acts are
That is
regularly
true.
performed. Now, once that presumption is there, who has to give a rebuttal? One who says it is not regularly performed. Because Mr. Payang, that is why in the morning in the first matter, we had already dictated the order. We could have changed it. But propriety demanded that we should come back to the, the matter should be placed in the open court and then we take a call. Because we expressed our opinion that we are dismissing that matter. And therefore transparency is required. And to say that the judicial act has been regularly done, we have listed the matter to change our opinion. Nobody would have questioned us. If had we altered the order,
Yes.
nobody would have questioned us. But since it was touching whatever it was, it's one has to be, the conscience has to be gluten free. We placed the record before you on the last occasion, and then today we have expressed our opinion. So that is our view of a judicial act being regularly performed.
My lord, your lordship may kindly see what the honorable apex court in para 16 of the judgment says, my lord. Because only for this reason, my lord, the certificate has to be verified at two stages. The first, the authenticity of the certificate itself. That is, they have verified authenticity. There is no issue.
You have read the book of Guwahati High Court on history. What is that? Heritage and history. Heritage and history. You have seen that? A
No, I
copy is
have-
there in the library.
I haven't gone through, my lord.
You see, there is a recorded case of the what you call the tribal adjudication in Arunachal Pradesh. What happened was that there was a, I have said that earlier also, there was a dispute with regard to a parentage of a particular child, and it came before the village court. It's there in the that book. So it came before a village court. Village court took cognizance of the claim of the parties and said that we will decide this matter after 10 years. And matter was adjourned. After 10 years, these village elders remembered that matter and took up the adjudication. The boy was brought. And the face of that boy resembled a particular person. And he says that the father of the child is this. And the matter was decided. And it was accepted to be correct after 10 years. So you see, at that point of time also, these people had,
Issue.
whom we so say that they are uneducated, those people had the wisdom to find out a DNA test by oral examination. And they were right. This, they accepted it. The judgment was never criticized. So you see, that is how these evidences are led. Now, if to a witness who is a proceedee, you don't ask any question. You don't question the Lat Mandal.
That is definite, my lord. We should have make some inquiry. That is a different.
Para 16 does not
Para
say
16
that even if it is proved, because of the
Evidence, my
contemporary
lord, what my
record,
submission is that, my lord, the document is proved. The content is not proved. Document is different. Document, proof of document is a different, my lord. And the contents of the document is not proved. That is why my submission, my lord. On what the content has from these documents, my lord, from his evidence page 60, content is not proved. My submission is that if the contents are proved by his evidence,
that's
then
not your submission. Your
there
submission
can
is
be
the
my lord,
content
some
is
more-
proved.
No.
But still, he is the daughter of that person.
No. My fact is that the document is proved by exhibiting, my lord, D1, D2. The document is proved. Now, content, who will prove the contents? My lord? Content has to be proved by him. From this his evidence, from the evidence of the Gabura, from the Lat Mandal, it is nowhere seen whether the contents are proved. That is the question, my lord. If contents are proved, content has to be, how the content has to be proved? That is settled, my lord. Content has to be proved on the basis of contemporaneous record. The certificate, if a certificate is issued, certificate has to be proved on the basis of some contemporaneous record. Where is that
No,
contemporaneous
then you see,
record?
then if the contemporaneous record is there, Supreme Court wouldn't have analyzed it and said that for a married woman, please have a
No,
ring certificate.
that's why, my lord, this says the letter process. That's why in the Supreme Court says the
Please read that.
second part, but the contents, the first of the authenticity of the certificate, that is proved. We have accepted, my lord. And the second is the authenticity of the contents thereof. Authenticity of the contents who will prove, my lord. The letter process, that is the authenticity of the content of the verification, is bound to be an exhaustive process in the course of which the source of information of the facts and all other details recorded in the certificate will be ascertained after giving opportunity to the holder of the certificate. So this part has to be done. That is my submission.
You see, we are finding it very difficult to accept that proposition.
My lord,
You see, I'll tell you very simply. Read it again.
on this basis, we have numbers
The
of
letter
judgment of the
process of verification is bound to be an exhaustive process in the course of which source of information of facts and all other details recorded in the certificate will be ascertained after giving an opportunity to the holder of the certificate. Now, who is giving that opportunity? This is to be done by whom?
This is second part, my lord. It is to be done by the certificate. Who has issued that certificate?
Where is the proof that he has not done it? Where is the presumption?
My lord, your lordship will find page 60, my lord. No record. He has not brought any record. He has not said this.
No. Where
What-
you see, you should have, the home department should have issued a circular that once you do it, contemporaneous record, please produce it.
No, my lord, that is there. My lord, that is
No.
whatever, my
You
lord.
see, then the tribunal should have sent it him back.
There, Lordship, I agree, there are lapses on the part of the tribunal also, but
No, you see,
in spite of knowing that,
No,
Lordship, we are
please tell
placing
us.
it before
no.
Lordship now.
It's a second question. Now you see, so far as my limited experience I have gathered, which is of course from the civil court, is that any entry which is in a draft is a secondary evidence. You see why? Let us say draft chita. That's one. Second, in a examination, in the right side, you get a space when you do maths to give the steps which you have taken. And if the steps are wrong, the student knows beforehand. If the steps are wrong, then the answer is wrong. Even if the answer is correct, because of incorrect steps, he does not get, or he or she does not get any marks. Very clear? Now, therefore, when I was a student, when it comes to maths, that steps are required to be done. When I was a student, that was the law. So those in the right side column, I used to write the correct steps and then get marks. Correct. So therefore, when this document came to the tribunal, you see, you have a different perspective since you are defending. Now, the purpose is that when you see, you know about when you were in the tribunal cross-examining you means your state, not you personally, but state. They are aware of this Rupjan Begum. They are aware of the contemporaneous requirement of records. But when a witness comes, doesn't ask any question, that means 114E is perfect. There's no question to that. Now, where is the material before the tribunal to arrive at a finding that the contemporaneous record not being there, Rupjan Begum not followed, and therefore I discarded? That is not the process. It doesn't elaborate. We would have accepted your proposition if that was the consideration. But then the tribunal has, you see, when there's no cross-examination, then for a court to discard it would be without giving a notice to others, because otherwise if he had a notice, he would have rectified it. The tribunal issues a notice to the Lat Mandal to come. And if the court knows, the tribunal knows that this document is required, it would have referred it in the notice. You don't do that.
In fact, the notice was issued to the circle officer, my lord. The
He didn't-
Lat Mandal was not issued.
No.
Because he is the one who issued the certificate.
No, my lord, he said this circle officer issued the certificate.
No.
It's the Lord Mandal.
Lat Mandal.
Therefore, he was sent.
Now, this is,
Rightly.
we had a question also here. My brother had pointed it out. You see in the document,
Yes.
in the top it is written in the office of the circle officer.
Circle officer.
So is a circle officer's office, can it be used by can it be
Lat
signed by a Lat
Lat
Mandal?
Mandal.
But you don't put that question.
Lordship, I have a small prayer, Lordship. Lordship may send it back for reappreciation and give the state a chance to do the cross again. Most of the times it is the petitioner who gets this chance, but this time we
That's
are
why, you
back
see,
for a
that's why,
chance for reappreciation.
that's why we wanted your input.
Yes,
You may not like to express so many things here. So we wanted your input. That's why we are asking you to please come so that
matters where we have got this opportunity by the court, that it has been sent back.
this will happen
and
only
it
when
has had the
when
opportunity
the
to
state
re-
comes up and tells us things, then only on the judicial side we can accept it, because otherwise it would be
This time the cross and everything has to be, the effort has to come from the state. Because there have been some judgments like this, Lordship, earlier. Justice Bijor Bora had passed these judgments. That where the state has not done the cross, so if the matter is sent back, remanded back, but at the same time, the state will also be.
no, that will happen, Ms. Verma. We are not against what you are saying, but this prayer must come from your end.
Lordship, I'm making
Ah,
this
ah,
prayer,
ah,
Lordship,
yes,
I'm
yes.
humbly submitting. That if there is a lapse on our part, we should also be given a chance
No,
to
definitely.
cover it
Why
up,
not?
Lordship.
Because otherwise, for all other purposes, secondary evidence, which is a calculation sheet and all, is not required to be kept. You see, there's if you try to find out, you will come to know that only the original records, which are the entries, are a document which is required to be retained by the government. Otherwise, after 7 or 8 years, I forgot, in the general circulars, the documents are required to be distracted. Therefore, it is only the final record of proceedings which are required to be kept. And once it is entered, you see, once it is entered in the record of rights, then contemporary records are not maintained. You see, when you say contemporaneous record, what do you mean? That there must be some record existing at that point of time. Then the state in this, what do you call that, that earlier case you said, what is that? What was that case where, how did that link certificate came?
Rupchan Beg.
Oh,
No, Manwara. huh. So there, the state would have spelled it out. That contemporaneous records are this. You see, the difficulty arose when the contemporaneous records were not there and linkage is required to be proved. Then to say fall back on contemporaneous records is a self-defeating purpose for this certificate. Otherwise, this certificate is not even required. If there is a contemporaneous record, why you need a secondary evidence?
Lordship, I'm just submitting what I am understanding is for the purpose.
Before that, please understand the proposition. You see, number one, if there is a contemporaneous record, that is a primary evidence. And this link certificate would be a secondary evidence
Secondary.
because you are looking at a contemporaneous record and then creating a link certificate, correct? So, is it otherwise permissible in law to have a original record that is a primary evidence and then ask the state to issue a secondary evidence? It is because the link certificate is required because of the fact that the primary evidence is not available.
And in the process of that, Lordship, most of the documents are manufactured. Because in the absence of original records, people are falling back on documents or these documents have come out, Lordship, which we can find it when we go back to do a recheck on them. Sometimes they're not found in the
We'll
records.
resume at 2.
Yes, Lordship.
Yes, anything more?
My lord, as we have, my lord, submitted before this noble court, the
No, to reply to the submission of
yes,
Ms. Verma,
yes,
that although this document is there, but the link to that person of is not established.
now that answer has already been, my lord, before us by this honorable, my lord, full court in a Muslim Mundal case, my lord, lordship ever. I will not go through the details, my lord. Now,
What does it say?
Uh,
How is it
Lord-
in your favor?
my lord, the positive statement of the evidences, if are not abated, my lord, disputed, its amount to, my lord, admission as held by this, lord.
Show that.
Now, my lord, that statement lordship will find the Muslim Mundal case, my lord, para, my lord, 121.1. There are 121.1, my lord. Middle portion, my lord, may I read, my lord?
Just a moment. Para 100,
100 my lord
21.
21.1 and my lord another paragraph my lord 122.1.
$122 point.
122.1 my lord.
Please read that part.
My lord 122 my lord. Last 4 lines my lord. Apart from the examining the exhibit 1, the report, no rebuttal evidence also could be laid by the state to demonstrate that so and so is not the father of the appellant whose name appeared in the aforesaid electoral rolls. So in our case also, my lord, there is no rebuttal, my lord, from the part of the state. And what has been stated, my by the evidence, my lord, so and so is the father of the petitioner. That is, my lord, is holding the field.
You see, if we read this Muslim Mandal, the paragraphs we are referring to, in one of the previous paragraphs of this, it has been mentioned that this lady had proved, you see, this finding was arrived at because this lady proved a school certificate which contains the name of her father. That is a contemporaneous record. You please see 1 or 2 paragraphs here and there, you will find that.
121 my lord.
121, 1 or 2 paragraphs before that, you will find the facts given. The lady exhibited her school certificate. That becomes a linked document. What Ms. Verma and Mr. Payang were arguing was that the document is there, contents are there, but contemporaneous document is not available.
Exhibit B and Z.
That much I will not remember.
Yes, it is there.
Hmm.
Lordship, but giving a reply to what my friend has
No, just let
stated.
him complete, then we'll come back
Yes.
to you.
That is, my lord, paragraph my lord 122.1. The tribunal has rendered his said opinion was rejecting the evidence adduced by the appellant on the ground that the appellant could not prove that her family members have been living in Assam prior to so and so. The tribunal has also held that the exhibit B and exhibit C, there is the electoral roll of 66, 1970. The name of so and so, so and so, so and so appeared in the NRC 1951, Exhibit G. The father's name of so and so is shown as so and so. The tribunal also found the discrepancy in the age of the Imtiaz Ali as mentioned in the Exhibit B and G. The tribunal, however, overlooked the evidence of the appellant that she was born and brought up at village so and so police station, and she was a student of Medetri High School. The appellant also has proved that the exhibit A is the school certificate issued by the headmaster, which was not disbelieved by
Just
the
a moment.
tribunal.
Muslim Mandal to Ulva from 38 to Ulva under section 9, 24 into paragraph 47. Section 9 to 12. 9 of 1. Muslim Mandala case file. It is 2013 1 GLP to size of section 9. Yes, Lordship. One 21, yes, Lordship.
120.1.
Hmm.
120.1.
Yes, Lordship.
Got it? There being an evidence on record,
Lordship is reading 120.
120.1, last 4 lines, 4 lines.
Yes.
There being evidence on record. That's how it starts.
Lordship or Lordship is reading from below.
Yes, below.
Yes, Lordship.
You got it?
Yes, Lordship.
The point bottom in the state of Assam, and there being no evidence, not even an allegation that the applicant's parents are foreigners.
Mhm.
Now, what is this? And if there's no allegation, there can't be a reference. Why is this?
Maybe our paragraphs are not matching. 120.1.
0.1,
It
120.
is Writ Appeal 268 of 2008.
No, 120. There's Muslim Mandal.
Yes, yes.
Yes, Muslim Mandal.
280.08,
Yes, Lordship.
120.1, last 4 lines. There being evidence on record. After there is 25.371. Last 25.371. After that. In your copy, 120.1, how does it start?
In my book, 120.1 starts with the record of the tribunal release.
No.
Reveals.
No. Just after 280.08.
280.
280, writ petition, 280.
Yes, Lordship.
Just after that.
No, this is 121. The tribunal has
121, last
rendered.
4 lines. Huh?
Yes,
There being
Lordship.
evidence on record.
Yes, Lordship. That the appellant is born and brought up in the state of Assam and there being no evidence, not even an allegation that the appellant's parents are foreigners. The tribunal ought not to have opined that the appellant is so and so. That being the position, both the orders dated so and so pass as common judgment. Discharge, the appeal is accordingly allowed.
You see we understand the point. Number one, in every reference, it is the reference based on the allegation against a person. Now, this person is alleged to be a foreigner.
Yes.
Now, what does this 120.1 understand? We understand that there is not even an allegation that the father is a foreigner.
Then because
So in every case, you don't have a reference like that. Even in this case, you don't make a reference that the father of the petitioner was a foreigner.
No.
What do we and what?
Lordship, the father existence in Assam has to be between 66 to 71.
No, I'm not on that.
That is how we link that.
No,
he-
I'm absolutely not on that. This Muslim Mandal must have been a case where there's an opinion that he is a foreigner. And that is the opinion for which the matter was sent to a tribunal. Reference was never there that Muslim Mandal was a son of a foreigner and therefore he should be thrown out. Correct. Now, it is in that context, how
Yes.
does this paragraph fit in?
121.1.
Yes. How does this last part? No, not even an allegation that his father is a foreigner. How does this fit in the scheme?
There may have been a faulty reference which has come to their notice because it says there being evidence on record that the appellant is born and brought up in the state of Assam and there being no evidence, not even an allegation that the appellant's parents are foreigners. The tribunal ought not to have opined that the appellant is a foreigner on the ground that the appellant failed to prove her family members.
Correct.
The records must have shown that
No, I'm not in that. You see, I'm on how this part fits.
fits into.
Because in every case, now if you take this Muslim Mandal, which is a 3-judge bench decision, that if the father is not there's no reference against the father, there can't be anything against the son.
If they are biological same belonging to the same family, Lordship. here is the case where the biological father, even if he is their lordship in most of the times, 66 and 71 documents which are placed before or which are exhibited, they are no longer there. And the next document comes after 13 to 15 years, the next voters list. The continuous stay is not there. The projected father, mother's name have been picked up, and the names, that no wonder we have so many aliases. Because sometimes the father passes away 19, 20 years before, but the name continues and the village also continues. If a person has passed away after 3, 4 years, the name ought not to have been there in the voters list. But it continues if lordship sees. I'm talking on a general basis, lordship. I'm submitting this on a very general basis.
This would be.
Which segment, lordship? Yes, lordship, here it is.
The print I can find faster than reading on e-mode.
Lordship, I just want to place on the rebuttal on evidence by the state. Lordship, I would just like to read out in.
Just a minute, just a minute.
Our citations are almost torn now. We have a new set, lordship.
Co-binding, let's see.
কিমান কৰিব ভাঙি যে ছিঙি যাও
Mhm. Mhm. Extensive. This is interview showing a bill. Okay. This is one thing. The tribunal found to discuss the age of interview. Prevention is one support. It doesn't have any evidence. The village have from the village tribunal. And she was trained by the region of high school. Evidence to discuss about ABC to আহিব. Discussion in this case. You see, we are sending you back. This query is because of this. It's 280. Repetition 280, 121.1. You look from the top, you will find there's a discussion of exhibit B and C,
Yes, Lordship.
correct? And then court says that the tribunal overlooked the fact that she was born and brought up. But for born and brought up, no exhibit is referred to.
Yes.
Next line is that she was in the Mediati school.
Mhm.
So therefore, just because she's in a school, there is a presumption that she is born in Assam.
Yes.
Because on facts we don't know. 280, what is the facts we don't know?
We
There's
do not.
nowhere mentioned
Yes.
except for reference to exhibit B and C.
Yes. Lordship, here it mentions.
That's why the question was, how does that fit in the present case?
Yes.
I am not saying about the legality, it is about fitment.
Regarding the rebuttal part, Lordship.
The part.
Yes. My friend has placed Muslim Mandal. I'm also placing something from Muslim Mandal only, Lordship, in one of our judgments where the state had failed to rebut the evidence. There was no rebuttal. So the judgment goes as this, like this. On the other hand, from the impugned
You reading
order,
which paragraph?
Lordship, it is 2018 4 GLT 360.
Just a moment.
Yes, no, whatever. I have one copy of
2018 4.
GLT 360. Lordship, I have one copy if it helps, Lordship. I'm just skipping the facts, Lordship.
Hmm.
I'm coming to paragraph 16 where this court has held that the tribunal observed that the state did not examine paragraph 16, did not examine any witnesses and failed to adduce any rebuttal evidence. Therefore, tribunal answered the reference against the state. We are afraid the approach taken by the tribunal is contrary to the law laid down by the full bench of this court in state of Assam versus Muslim Mandal. Under Section 9 of the Foreigners Act 1946, burden is on the proceedee to prove that she is not a foreigner, but a citizen of India, and this burden never shifts. This burden has to be discharged by the proceedee by adducing evidence which are admissible, which must be proved, and which must have relevance to the facts in issue. By mere filing of documents without examining its admissibility and without the documents being proved or without examining its relevance, it cannot be said that the proceedee had discharged his burden. Question of rebuttal evidence by the state will arise only if the proceedee adduces evidence which are admissible, proved, and which have relevance. So this has also been taken up, Lordship. And the most important thing is, Lordship, which must have relevance to the facts in issue, because every case has new facts, different facts not matching. We do not have a set pattern of documents here, Lordship. The only set pattern which I have noticed in my experience, Lordship, 66, 71 is always same. After that 13, 15 years, the villages change, there is shifting, the places change, the names disappear from the voters list. And all of a sudden, after about 15, 20 years, we see some voters list which has the name of all family members. Once the documents are all in place, then everything is in order, no shifting. They even have the EPIC, they have the Aadhaar, PAN, everything. And despite being declared foreigners, they are still voting. Burden of proof. Which Muslim Mandal Lordship, Muslim Mandal. Lordship, same paragraph, 120. I will just share it. I've just kept the judgment open, Lordship.
Yes.
My lord. Facts. Yes. My lord, Muslim under full bench, my lord. We have referred. Now, my lord, the decision referred my friend, my lord. Lordship has seen page 16. The 2018 4 GLT, my friend has referred. Paragraph 16. This is my lord, squarely covered the petitioner case. Rather. 16, 1-6. Yes. May I read, my lord? On the other hand, from the impugned order, we find that after (360). Okay. Itu like this. Let's say itu. Itu. Paragraph 16, minute. এটাই তো বলেছেন আর একটু মুখ দিয়ে একটা কপি না পুরানো
You don't have a copy? don't
কপি
have-
আছে লিখলো
আপনার লাগবে একটু নাও।
Paragraph 16, minute. On the other hand, from the impugned order, we find that after narrating the case as projected by the respondent, tribunal observed that the state did not examine any witness and failed to adduce any rebuttal evidence. Therefore, the tribunal answered the reference against the state. We are afraid of the approach taken by the tribunal is contrary to the law so and so, so and so. Laid down by the full bench, this court so and so, so and so, so and so. Under Section 9 of the Foreigners Act 1946, burden is on the proceedee to prove that she is not a foreigner, but a citizen of India, and this burden never shifts. This burden has to be discharged by the proceedee by adducing evidence which are admissible, which must be proved, and which must have been relevant to the facts in issue. By mere filing of the documents without examining its admissibility and without the documents being proved or without examining its relevance, it cannot be said that the proceedee had discharged his burden. Question of rebuttal evidence by the state will arise only if the proceedee adduces evidence which are admissible, proved, which have been relevant. Now, in the given case, Lordship has already seen the exhibit D was proved. It is not that the document was not proved. It was proved by bringing evidence before the tribunal. Now, the state has to rebut it, but failed. So this is also supporting our case now. The findings. Now, my lord, another aspect, my lord, I would like to draw your lordship's attention. The my lord, purported report, verification officer's report, lordship will find page 18 in the writ petition. Yes.
1-8.
1/8, my lord. Of the writ petition, lordship will find only, my lord, name has been written and her husband's name has been written. A document not produced. Page 19, lordship will find, my lord, entire column is vacant. Page 20, lordship will find entire column is vacant. Similarly, page 21, the, my lord, crucial part of the prescribed form, lordship will find page 21, paragraph 16. Now there is a three, my lord, area, my lord, A, B, and C. Lordship got it. Page 21, column 16. Whether migrated, column A, before 1/1/1966, column B, between 1/1/1966 and 24/3/1971, C, on or after 25/3/1971. Lordship has seen page 21.
Any document.
That has been, my lord, that has been alleged. But the inquiry officer ought to have mentioned which stream the petitioner are suspected to be.
Unless you produce
How
documents.
will they? Yes.
How
This
will
verification report is, my respectful submission is made in the office of the, my lord, officer concerned. They have never visited the office area.
But this plea has not been taken up before the tribunal, lordship. It is the first time my friend is coming up with this plea. If he had a difficulty or a doubt on this document, he should have brought it up before the tribunal. There is no mention about it in the opinion, lordship.
Now,
And if
since-
no document is produced, nothing, lordship, how does he expect the next 2 pages to be filled up with?
now let me complete, madam.
Yes, yes,
Now,
please
with this
complete.
regard, my lord, I would like to, my lord, citation to be. My lord, the decision of this honorable court, my lord, 2022 Court GLT, page 105.
Oh, oh. What is the name, sir?
2022 Court GLT, page 105.
Name of the petitioner?
Name of the parties, my lord. Sorry. Sorry, my lord. That is, my lord, 2022 Ford GLT, page 102, my lord. Party name, my lord, Amina Khatun versus Union of India and others.
Petitioner senior admin.
My lord, their paragraph, my lord, 13, 14, and 16.
Before 1966 will mean citizen.
Yes. Those coming from specified territory lordship.
Before 1966,
66, yes.
they are citizens.
That is, there is no, dispute regarding that.
66 to 71 is 10 years.
Yes.
And 71
Post.
post. So when you don't produce any document, hypothetically,
Well.
you are obviously not falling into the category of 61, 66,
To
1 and 2.
71.
66. If you are a person coming from specified territory prior to 66, then obviously you'll have some documents to show that you had migrated these, that relief camp, etc. So 66 is out. 66 to 71 is also not there because there is no evidence.
There is a document, voter list of the father's name,
No, I am talking about page 21.
page 21. Yes,
So when you don't give documents, subject to correction, there can only be two conclusions, either of the two.
yes.
Either you are a citizen, born and brought up in India, therefore no documents for whatever reason, or you fall into the third category.
Now lordship has seen, none of the columns are filled up.
That's what we are saying. Assuming there is no detail given by in this particular document, page 21, what would be the ultimate analysis? If you belong to the first category, that is before 1966, you're bound to have some document.
Yes.
You did not produce it, assuming you had one. What 66 to 71 also, you'll have some documents. You will not have documents only if you fall under number 3, or you are a citizen in India.
Yes, now that has been held by this honorable court. Malad, as I have Malad reported, Malad cited, Malad, this Malad court, 2022 4 CLT, page 102. This court has held, Malad, by the division bench, Malad, lordship will find there para 13, 14,
No,
15,
no.
16.
We are traveling a little beyond that. This court has held that yes, there should have been some detail. You fall under which category?
Correct.
Now, in a given case like yours, assuming there is no detail,
Yes.
if you probe a little deeper, what is the ultimate analysis that you
Now
have?
that is the case, Malad. Our case is covered by this decision also. Exactly identical case.
See, I ask you a question. I ask you a question, you don't respond.
Correct.
Correct. Then what would be the answer which I write in my tabulation sheet? Like say, for example, let us say practical examination in science stream.
Correct.
Chemistry. So in chemistry, there is some calculation given, and the teacher asks, what is this? What is this equation, and what does it lead? If these two chemicals are mixed up, what will be the outcome? The student doesn't answer. Then what would be the what you call the examiner right when this problem is given in a practical examination?
Now that situation.
So because if answer is not given for everything, this is just no document given.
Correct.
But once Ms. Verma says that the initial objection by the petitioner was not on that count. So therefore, we'll have to presume that this objection has been waived. In a writ petition, we can't examine that. Whatever was waived in the tribunal. So in fact, that is what my esteemed brother was asking you. When we go a little deeper, what do we find?
Yes, my lord, that is fine, my lord, absolutely correct, my lord. But I am showing the, my lord, how the, my lord, matter is going on in the, my lord, grassroots level.
You see, we'll demonstrate. You want us to demonstrate what is happening? We'll tell you. This reference was made when? What is the date of reference?
Normally, my lord, the date is not given in the report.
Lordship, it's a reference of 2007.
2007.
Yes,
Now,
Lordship.
please show us a document which is prior to 2007. Exhibited documents existing prior to 2007. Which is that document in your exhibited documents?
Prior to 2007. Yes, lordship will find in the first document, lordship will find at page, my lord, 31 first, my lord.
31.
31. Page 31. This is something, my lord, a revenue receipt by the, my lord, grandfather of the petitioner. 6/12/1947.
This is a Tozi paid
My lord.
by one R. Sharma, BL.
My lord, for whom the Hawaii, lordship will find in the vernacular, page 32, Hawaii Sheikh. Hawaii Sheikh is the, my lord, grandfather of the petitioner.
Lordship, owner is some Shri Shri Bhairav Bendra Narayan. Page 31, the translated copy has the owner's name, Lordship.
No, that is the landlord, Jamindar.
Zamindar.
Jamindar accepting is whether it is a public document, we don't know. But it's you see the word, it's the word Jamindar which you will find from below. Ader Tariq Sri Bhumadhik Kari अथवा so and so. So therefore it is he is the owner. In the first line you will find Malik Shil Sri Yukta Raja Bhavendra Narayan
Or Bokke.
who?
Some Sharma I can see.
Yes, that is Mr. R. Sharma BL.
Yes.
Uh,
After that.
so that is the main paid.
He's the manager.
My lord.
R. Sharma is the manager.
It is some Bijni Raj estate. At page 34, I can read little bit.
Is Sri Sri Yukta Raja. Bhairavendra Narayan. Who?
We are okay. Kati অবকৃত নিযুক্তি manager.
This one.
Yeah, R. Sharma BL.
My lord, we are having the, my lord, original copy. If your lordship is to see, my lord.
It's okay, we are not disputing you,
Yes.
but that itself. You see, there are reasons we may not be able to accept it. We told you, we gave you the description why.
My lord.
This is a receipt which is issued under the Gwalpara Tenancy Act.
Yes.
So when there is a tenancy receipt,
My lord.
a landlord-tenant relationship has to be established.
My lord.
So for the time being, it's okay. We have a document, but this is the only one.
Yes. But next lordship
No.
will find page 35. The NRC.
NRC, we don't have that. 12/8/87. Okay.
Then page 38 lordship will find. This is also, my lord, NRC.
We don't have the date of public printing. You see, this voter list is again 16/11/16. So all these documents are procured data. The NRC, we don't have the printout date.
Yes.
This,
But-
this NRC copy was when it was uploaded, lordship, for the purpose of NRC, all this was collected from the districts and updated in the system. Then all these documents had become public documents. So anybody could take out a printout and connect themselves with these documents.
No, that we understand, but otherwise the voters list and all their documents which are post inquiry.
Yes,
So at that
lordship.
day you had a document is not available even from record.
Then thereafter lordship will find page 39, the voter list 1953.
No, you see the date, it's 16/11/16. So these are all procured later on.
Yes.
So on that day, on the day when the verification was being made by the SP border,
Correct.
on that day you had no document.
That day it was not, because after the
No.
notice from the tribunal,
You see, we are just trying to tell you, we had been once there. At one point of time, we both were there where you
Yes.
are standing. So this is the part we know, how to cross-examine. That is something we both know. You're just exercising, you're just demonstrating that. You see, it is your case that you had the documents, but the verification was never done.
Malay.
You're just trying to demonstrate it may not be correct. Because when you have a certified copy of 2016, that day you may not have a document. But that's not all. We are just making a passing remark. We are not making any comment. It's a passing remark. That's all. That's all. And your submission is that once we accept the documents, then assuming we wish to remand it, then you should also get an opportunity.
Yes, lordship.
Okay.
But again, lordship, the burden is on the proceedee first.
Yes.
Yes,
that is the
Muslim Mandal, we are not
yes.
interfering.
And only the rebuttal comes only for those documents which are admissible in evidence, lordship.
We won't like to comment there for the time being. Brother. There are many reasons. We don't want to comment right now.
I am just stating because it is there in the judgments also, lordship.
Which one?
The state judgment which I placed, Wahab Ali, lordship. It said this, if lordship sees section 9 of the Foreigners Act, it is very clear. It
Please,
says,
please
it-
do a favor. both of you write the judgments which you are referring to. Because while referring, I missed out the context of one or two judgments. Please give it in a slip of paper, give it to the court master.
Mahabali, Monowara.
We'll furnish the list of the
List of books on which you are relying.
Lordship, one judgment we didn't place, but we would like to rely on. We
Exactly.
will write
And
it down.
only the,
Yes.
just indicate the paragraph also.
Starting to do it.
Because while asking questions, going through the records, I missed out your paragraphs and your
Mm,
misadditions.
Submit
So
Lordship.
you have to give him the judgment of whatever you are placing.
He has taken it down.
Hmm.
They are all online, Lordship. We all have copies of
No,
them.
no. The judgment which you are want to place it now.
Yes, we'll show it to him.
Let-
And the copy to your detail.
No, not a copy, just telling this addition.
Yes, we'll give the same slip to him, Lordship. Lordship, this is reserved.
When we work on the files at home, we don't even remember that we are online and we could go back and see what was being argued. We don't even have that much of time.
Order reserved, Lordship.
I say. Heard. Mr. M.V. Mandal, counsel for the petitioner. Ms. A. Verma, learned standing counsel for the FT. Mr. H.K. Hazarika, learned government advocate, and Mr. A. Ali, learned standing counsel for the ECI. Mr. Arguments are concluded, judgment is out.
obliging.
Item 5 for hearing.
May I plead your lordship? Lordship, in this case, my lord, petitioner's grandfather's name recorded in this Bhuta list 1960 and 66. My lord, page number 15, my lord.
Yes.
Yes, my lord.
How have you linked with your grandfather and father?
My lord, yes. Grandfather and father's, my lord, page 20, my lord, 1970, my lord.
Page
Page-
20.
My lord. Not 20, my lord. No, sorry, my lord, page 22, my lord. That is Bhuta list 1979, my lord. Serial number 180, Wajid Ali is this grandfather's, my lord, and petitioner's father's name is Kalamia, my lord, 186, my lord. And petitioner's mother's name is 187, Amina Khatun, my lord.
Page 22.
Page 22, my lord.
Page 22, this page 23 vernacular, this was not an exhibited document.
My lord,
Was this an executive document? Page
22.
23, you don't find that,
No, no, my lord.
then Ms. Vadida, when you are showing us a document, please tell us, because otherwise we have to spend time finding it out whether it was exhibited or not. We have to refer back to page 41, whether it is exhibited or not, then come back. It takes us some time. Just when you are addressing, tell us that this is not an exhibited document. Then we have a different way of appreciating that. You see, the only linked document from your judgment we find, this opinion we find, that there is an exhibit 4. And the evidence of the headmaster disowns you.
My lord,
Then you're disconnect with your father and your grandfather.
my lord.
Read page 41, exhibit 4 is disconnected.
My lord.
Then Ms. Barwa, you'll be doing that matter. You'll be doing the matter. Right.
My lord, all this voter list, my lord, I have annexed, my lord. There are no other documents, my lord, annexed.
Can I see the LCR dots? LCR. Hmm? LCR. I don't have the copy. Just a moment. Yes, sir. We wanted to look at something. What is the name of your grandfather?
Wajid Ali, my lord.
Hmm. Exhibit one, this is certificate copy, the next page. Exhibit 1, 2, and 3, there is a disconnect you have not been able to prove. Because if 66 goes, another document goes, 66 is discarded because the age of the grandfather, there is a difference of 51 years, which is not explained. Because if your version is correct, then your grandfather was 120 years of age. That was disbelieved.
My lord, that is wrongly recorded in this voter list, my lord, it is.
No, but for that, there is no explanation at all.
But my lord, I have annexed 1960 to 2005, all this, my lord.
No, because if
annexed is
66
voter
goes,
list, my lord.
if 66 goes, then there is nothing which connects you. And then again, there's a difference of the name of the mother. The reason for discarding this document is already there, Exhibit 2. Because the repetition, we don't find anything which by which privacy it would appear that this Exhibit 1, 2, and 3, the discussion was incorrect.
My lord, age is always, my lord, incorrect, because my lord, earlier, this recorded in this village, sitting here, village headman's home, my lord, and one by one recorded, my lord, this, that's why, my lord.
No, it's okay. You see, it's
My
not
lord.
only the age. Age is with regard to your grandfather and grandmother.
My lord, petition,
the-
I
But
still,
the other documents, you see, you are exhibiting a document
my lord,
that this is my father and my mother. But there's a name difference. If there is any documentation to show that the mother had different names, then we understand. But otherwise, it would be very difficult. Anybody can pick up a voter list and then establish. Your voter list, 85 voter list also goes. Because you can't, you have given evidence of this voter list and you can't identify people. You see, you come from a village. This petitioner, they comes from a village. In village, everybody is expected to know everyone. They are not residents of Guwahati, where I don't know my neighbor. My experience in village is that if you move around in a village, people will ask you where you want to go, and then they will give you exact direction how to go to that man's house.
But age is always my lord.
No, it's not a question of age. You in this case, you gave a voter list, you can't identify persons there. And they are residents of the same house. I don't think in this case you have been able to prove it. How do you overcome this opinion of exhibit 1, 2, and 3? What do you have to say?
My lord. Petitioner is still alive, same village, my lord, and if your lordship permits, my lord, if he has land documents, I have shown, my lord. But some more times given.
No, that we don't know about it, but today it's not there before us. It's come out after 7 years.
My lord.
We should have taken a decision before we open the file. If you don't have anything more to say, then we close the matter.
My lord. Petitioners have all this authentically, my lord, documents, my lord, up to date voter list, my lord, nothing else, my lord.
Voter list does not show.
And he is
You see,
still alive, my lord.
Ms.
still
Vasita,
alive, my lord.
you have done more cases than we have adjudicated. You have done more cases than we have adjudicated. Correct?
My lord.
You have more cases, correct? That matters in our cause list. You know the law more better. The voter list is there, but how do you connect? Because once you get disconnected with your grandparents, nothing remains. Then we close it.
After your
We'll
lordship.
pass orders in chambers. But this order would not be released before Monday. Realize there is a single bench. Take it up.
So that at one stage I can finish it up.
No, because you see, I'm in a bench where
I understand.
Daniel,